Hey my powerful learners, welcome to Asra's Education Power. In today's video, we are going to know about journal defense through an action in torts or journal defense and justification of torts. So let's get started with the video. Before starting, like, share and subscribe for easiest learning videos. So when the defendant cause harm or injury to the plaintiff has right of remedy by way of compensation in law of torts. However, in certain situations, the plaintiff would not get success even though he is successful prove his injury. The defendant pleads certain grounds for the justification of torts he caused to the plaintiff or to the property of the plaintiff. These are called journal defense or tortious liability or justification of torts. Under this ground, the defendant is excused. So, Sir Friedrich Blocker explains them the rules of immunity which limit the rules of liability. There are various conditions where when present will prevent an act for being unlawful which in their absence would be wrong. Under such condition the act is said to be justified or excused, and when an act is said in journal terms to be wrongful, it is assumed that no such qualification condition exists. Okay, let's see the main point. Which is the main point means what are the defense, what are the justification of torts. Here are 12. Okay, 12 excuses or justifications. First is volna non fit injura, plaintiff the wrongdoer, inevitable accident, vis major act of God, private defense, mistake, necessity, statutory authority, judicial act, parental and quasi-parental authority, dilatory defense, and contributory negligence. These are the 12 defense. Okay, if you are writing this for 10 marks, this is enough, or you can elaborate it. Means what is the meaning of voluntary non-fit injuria? Write few lines about this and continue as same 12. Write something about this 12 points. But if you're writing this for 20 marks, you have to write in a very lengthy manner, because for one answer only he is giving us 20 marks. Okay, so I am giving this answer for 20 marks. Okay, let's get started for the referred topics. Okay, first is volna non-fit injuria. What is the meaning of volna non-fit injuria? Let's just see that. Here, volna non-fit injuria means it is a legal maxim, which means damage suffered by constant is not a cause of action. Let us see this with an example. A is drowning in a water pool. To rescue him, B dived into the water and rescued A. While doing so, B receives injury. B cannot claim compensation from A. The reason is why? Because B has went voluntary to rescue A. Okay, so this was the meaning of voluntary non-fit injuria, and the two essential legal points of this is this one: the injured knew that there was a risk in the fact, and knowing that there was a risk, he invited it and it suffered it. You cannot put a blame on the situation or a person that because of you this has happened. Okay, this is the meaning of non-fit injuria. Let us move on to the second one. So here, plaintiff the wrongdoer, nullus commendum corpora posta de injuria so corpora, means this is a legal maxim, which means no man can take advantage of his own wrong. Means let us see this with an example. Okay, A is a wife of B and C includes A to divorce B and B gave him 50,000 rupees to A. A does not give divorce to B and remains with B. A cannot sue. A cannot sue. Sorry, C cannot sue A for the recovery of sum because C himself is a wrongdoer. He was burning the misunderstandings between A and B. C was burning misunderstanding between A and B. So he cannot sue A. Okay. This is the main. No man can take advantage of his own wrong. And other legal maxim is ex culpa cause non urtur action, means from an immoral cause no action arise. Okay. Let us see one more example. A possesses a citizen watch. B steals it from A. From B, C steals it. A sue B and C. Okay, A have sue B and C, but B cannot sue A or C. Being himself a wrongdoer, he cannot sue A and C because B have steal the watch from A. Okay, got it? And the next topic is inevitable accidents. Inevitable accidents. Here, for unavoidable accidents, an act of God, you can view my shorts in my channel for clear understanding. These are the unavoidable accident and these are the act of God, clearly explained in my shorts. Please view that. So here, what is the meaning of private defense? It is a good defense, and in criminal law also it is very good, and also in law of tort. Okay, it is recognized as a good and justable ground. The law recognized one's right against his person and property. It is a duty of every person to protect himself and does not depend on anyone or his property. If any person invades against him, he can successfully react with reasonable force and required for your self defense. Okay, in doing so, if he caused injury or even death to your wrongdoer or defendant, he shall not held any liable. He is not punishable. If you're doing your self defense and any person died, you are not liable for any punishment. Okay, if a woman for her self defense murdered any person, she is not liable for any punishment. Okay, any punishment, because you are doing your self defense, and self defense is a good defense. So let us see this with an example. An old woman enters into the house of B to steal some rice. B have beaten her with a stick very severely, and A died. Here B used excessive force, hence B is not entitled for field of private defense. Okay, see this. An old lady entered into the house of B to steal some rice. Okay, B have beaten her with a stick very severely, and A died. Here B used excessive force, means excessive force was used to her self defense. A have died, right? जिसका घर था वो मर गया, but here B have used her self defense. She was the old lady, right? So she have used a self defense and she is not liable for any punishment. It was a private defense, it was a self defense. Okay, moving on to the next topic. So here, mistake. Here is a legal magazine. Ignorantia facti executa, ignorantia juri non executa, means ignorance of fact can be excused, but ignorance of the law could not be excused. mistake of fact is defense in criminal law as per the section 76 to 79 of Indian Penal Code 1860. However, law of tort, neither the mistake of the fact nor the mistake of the law stands as good defense. Okay, and A, let us see this with an example. A has to pay rupees 1000 to the B, and D has to pay 1000 to the C. A sends E with money to give it to the B. Okay, by mistake, E have given the money to the C instead of B. A sue C, and C can plead that he was mistakenly given the amount which was paid by E. Okay, so C has to refund the amount of A. However, he cannot be guilty for convention. Okay, this is the mistakenly given amount. We have to give it to the one person, but we have given to the another person. Okay, this is a mistake. And second is seventh one is necessity. What is necessity? Here, necessity. Here is also a legal magazine. New lista inquit privilegia privilegium quada jura previcta. Sorry for my this legal language. And this was a legal magazine, which means necessity gives a privilege as to the private right, where any wrongful act were done by a defendant to save his life or property under unavoidable situations, he can be excused. It is a good defense in criminal law. The same magazine is also helpful in the law of tort, and it's also become a justifiable defense for the tort fearer who is compelled to do certain damages to any person or to do the property of any person to prevent greater damage. Let us see this with an example. A house is burning. B has came and removed the roof of the house with an intention to stop the fire and to prevent it from further spreading. Here B act is an intention to help to A. In doing so, he might have caused certain damage to A house. B's act is justifiable under this circumstance. Means A house was burning, so B has came and removed the roof with the intention of stopping the fire. So here B is justifiable. Means he have reason to do this. Necessity. Okay, it was necessary to remove the top of the roof to stop the fire. Necessity. Okay, sorry for my language breaking. And let us move on to the other topic. Next topic is statutory liability. What is statutory liability? Here is also a legal magazine, which means salus populus est superi lex, means which is rather for public welfare it is the highest law. Okay, the public welfare is the highest law. The object of this legal magazine is to give the safety and welfare to the majority of people. The government of India wants to construct a example. This is an example. The government of India wants to construct a big project like Nagarjuna Sagar, for which he requires huge land. Okay, if the said project is constructed, several lakh acres of waste land shall become cultivated land and shall be benefited to lakh of the people. Therefore, to construct this project, a few villages should be equitized by the government, and those people have to vacate their villages and agricultural lands. The land loser cannot complain against this. This is the statutory authority. Means if you are getting a benefit, if you are getting a huge benefit, you cannot sue or you cannot get against of it, because you are getting a huge benefit from it. You cannot go against to it. You have to sacrifice something for it. Okay, this is the meaning of statutory liability or authority. Statutory liability is complete defense and justifiable ground against the tortious liability. Okay. If you want an example, I will give you an example. Wait a minute. Here, if a police officer arrests any person on any reason, he should present the arrest person before the court within 24 hours. It is a statutory duty imposed upon every police officer. If he fails to do so, the arrested person can sue the police officer for this statutory authority. Okay, and this statutory authority cannot be helpful for the police officer. Did you understand the point? The police officer has to present the arrested person in the court within 24 hours. If he failed to do so, the arrested person can sue the police officer, and the statutory authority cannot help the police officer. Okay, let us move on to the next topic. Judicial Act. From a judicial first class magistrate to the chief guest of Supreme Court, all the judges, magistrate and other judicial officers who act judicially are protected by the Judicial Officer Protection Act 1850 in India. Okay, and no judge, no magistrate, justice of peace, collector or any other person acting judicially can be sued in any court for any act done by him in discharge of his legal duty, whether or not within the limits of his jurisdiction, provided that he at the time in the good faith believed himself to have jurisdiction to do the act complained of. Okay, means you cannot sue any judge, magistrate or justice of the peace, collector or any judicial officer. Okay, because to give the decision he has his own rights and he has his thinking and law included in his decision making. Okay, you cannot sue him. This is the Judicial Act, and by the Judicial Officers Protection Act 1850, the all judicial officers are protected. Okay, and it does not protect judicial officers from being sued in a criminal or civil court in their private capacity. It could protect the acts only in respect of act done by them in discharge of their judicial functions, but not ministerial. Means they can use their judicial power in court and by means for doing their decision making or doing their work, but they cannot be a dictator of it. Okay, using the judicial power, it's a good thing, but overusing it's not a good thing, and you can sue them for overusing their judicial power outside the court. Okay, if any judicial officer behaves negligently and willfully and cause harm to any person, he shall have be responsible. Means you can sue that persons, okay, who use their power for selfishness. This was the Judicial Act. Let's move on to the next one. Here, parental and quasi-parental authority. The parents and teachers are empowered to punish their children. However, the punishment must be reasonable and moderable. The Children's and Young Persons Act 1933, England, prohibits that the serious corporal punishments against the children. If a schoolboy schemes smoking, the teacher can beat strictly the boy with a cane. The punishment given to reform the boy is justable. However, the punishment should not be severe. Okay, let us see this example. In Malaysia, a school teacher punished his children, including girls, standing them in sun for entire day without clothes for not singing the national anthem properly is held not reasonable by Malaysian Supreme Court. Okay, this is an unvalid reason, right? She can teach them. Why are the teachers for? Okay, this was an example. So you have the parents and teachers should give punishment, but it should be in a limited way. You should not exceed the limitations of being a teacher or being a parent. Okay, let us move on to the next topic, which is dilatory appeal or defense, which means it is a distinction from appeals to the action and are defendant to be such as tend merely to delay or put off the suit by questioning the propriety of the remedy rather than by denying the damages, where pleas to the actions are such as despite the action the cause of action. Means, what is the meaning of this is a dilatory defense is a indicate to defense or delay or pending action without touching the merit of the case. Okay, and the dilatory appeals are also called as dilatoriness. And the next topic is contributory negligence. Let us see about this. So here, contributory negligence, it is a partially defense. The fault is divided between the plaintiff and the defendant. In contributory negligence, both the parties, that is the plaintiff and the defendant, are negligent. Until the incident occurs, both of them do not know the incident and its nature and risk. Both of them do not invite the risk. Okay, this is a contributory negligence. So this was your journal defense to an action in tort or justificationable of torts. I'm sorry for my language mistake and legal language mistake, and follow my channel for more such videos and in a understandable way. Thank you for watching. Like, share and subscribe. And if you have any doubt or if you want a video on any topic, you can comment down. I will definitely post it. Thank you for watching.